We're going to talk about property law. Property law is one of those kind of laws and areas of law that changes about once every 500 years. So we're going to start out talking about ownership, and then bailments, real property, and then landlord-tenant relationships. And that will probably be of some interest to all of you. The Fifth Amendment talks about property owners in that property is defined as consisting of the legally protected rights and interests a person has in anything with ascertainable value. When we think about property, we think about primarily real estate, don't we? However, there are other kinds of property. There's intellectual property, about which you heard Pat Collins talk a little bit ago. You have intangible personal property, which is stocks and bonds, and you have tangible personal property, which are things like furniture, houses, and then we have a thing called bailments. And bailments are a totally different kind of thing again as well. The right to hold property is protected by the Fifth Amendment to the Constitution, in that no person shall be deprived of life, liberty, or property without due process. Nor shall private property be taken for public use without just compensation. Yeah, Larry.
With that, so Fisk is considered public property because it's a historic landmark, right?
No, that's a different kind of thing. Fisk is private property. However, it received the designation of historic area. Historic areas cannot be changed without the approval either of the federal government or of some legislative body. So that's wherein that it differs. Okay? Personal property versus real property. Personal property is everything that is not real property. Okay, that's really cool, huh? All right. Okay, can I go to the next slide? No, I gotta stay there for a minute. Personal property is everything not being real estate. Consists of rights and an interest in a trust. So if somebody has a trust set up for them, that is personal property. Debt can be considered personal property if it's negotiated to someone else. Stocks and bonds, furniture, your car is personal property, jewelry, gold, and chattels. Now, what are chattels? You notice I get this little evil grin on my face when I say chattels. Did you know that cattles are chattels? You didn't need a dad joke? No. Chattels are movable personal property. It's something you can pick up and take with you. So if you pick up your furniture or you pick up your computer and you take it out of here with you, it is a chattel. And so cattles, because they move on their own, are also chattels. Okay. Goodwill in a business. We've mentioned goodwill before. What is goodwill?
The intangible worth of a business's name.
Excellent. What else? Well, overall, it would be what? Reputation, right? It's the reputation of your business. If you've got a good reputation, you have a lot of goodwill. Fixtures. Fixtures are things that go with the sale of land. They're intended by the owner to be appurtenant or attached to the land. Okay, appurtenant to or attached. That is something that is not a chattel. A chattel is movable. A fixture is not movable. Okay? Like
The board statute.
a statue or a light fixture, like the chandelier that you're all going to have in your mansions over the entryway, going up around the spiral staircase. I can just envision all of you having one of these. So light fixtures in a house, because they are in the ceiling. They were applied to the ceiling, and they will stay in the ceiling until we take them down. A fountain or fish pond in the garden. Garden gnomes are not fixtures. They can move, therefore they are chattels. In my calculus course, I actually have a picture of a plastic cow that somebody put in their garden. So the cattle would be a chattel, not a fixture. I'm going to put Justine to sleep. Attached to that's my objective for the rest of the night. You're welcome. Attached to the land somehow is a fixture. Okay? So let's say you have a sprinkler system, and the sprinkler system is not in the ground. If it's in the ground, it would obviously be a fixture, right? So you have this sprinkler system, and you run the sprinkler system around the house, and it's green, and it's around the edges of the property, and you put it down, and you have stakes, and you stake it down around the outside of the property. Is that a fixture or a chattel?
You said it's staked into the ground?
It's staked into the ground.
It's staked into the ground?
It's staked.
So
into
you
the
can
ground.
take the stakes out?
You can take the stakes out, but what do you think the court is going to say when they see the stakes?
That's attractive.
Somebody said it. It's a fixture. Yes, that's right. I didn't put you to sleep. That's good. There's an exception for trade fixtures. Okay. Fixtures are like all of the machinery that you use to manufacture the goods that you're making in your enterprise. If it is a fixture and it's part of your business, even though it's affixed to the floor and the ground, it is not a chattel, or it is a chattel. It is not a fixture. That merely attaching it to the ground does not make it a permanent fixture. So, machines attached to the factory floor that are a part of the process still belong to the business. Ownership. We have two types of ownership. We have what we call fee simple and concurrent ownership. Fee simple is when I own the whole thing. Nobody else owns any of it. It's all mine. This desk is all mine. I own it in fee simple. All right? Now we get to the good stuff. You will experience this in your lifetimes, I promise you. Concurrent ownership. Concurrent ownership means there are several people involved in owning whatever it is that you're possessing. Such as, you have a car. You get the car titled in your name and your spouse's name. That is joint tenancy in that automobile. It's joint. There are two people that are involved in the ownership of that car. Tenants in common generally are a whole bunch of people that own the same thing. So all of your cousins, if all of your cousins own part of a farm that you're inheriting, you can have tenancy in common. Tenants by the entirety and community property ownership refer to marriage. Tenants by the entirety is when spouses own a home. They own an undivided part of that home. That is tenancy by the entirety. You cannot cut, although there was a divorce case about 6 months ago in California. All my California people? In California, there was a divorce case. You know, California is a community property state. What does that mean?
Half of everything.
half of everything. So there's this house, and it's got furniture, and there are cars, and the judge ordered the husband to turn over half of everything to his wife. So he did. He cut everything in half. He cut the house in half. He cut the sofa in half. He cut the TV in half. He cut the cars in half. He cut the pool in half. It was so absolutely and utterly ridiculous. But there's beauty in all of that as well. He took it quite literally. I don't think the judge is going to be quite that literal ever again. Okay? So there's those two types of ownership: fee simple and concurrent. And concurrent is with others. Fee simple is by yourself. Tenancy in common, joint tenancy. We'll define these as we go so that you have a better idea. Tenancy in common. Each person owns an undivided fractional interest of the property. On the death of the individual, that interest is passed to the tenant's heirs. Okay? So, if there's my family, and my wife and I, and her two brothers, and her sister, we all own a share of this property as tenants in common. When I die, my part of that, my share of that, goes to my children. So then it would be my children are owners with her sister and her two brothers. When my wife dies, her share goes down to my two children. So they have our two shares combined, and then her sister and her brothers have their shares for their family. Okay? See how that works? Yes or no?
Yeah.
Okay. Joint tenancy. Each person owns an undivided interest in the whole, and a deceased tenant's interest is shared by a group. Oh. Joint tenancy says that if I and my wife own property with her sister and her two brothers, when I die, my shares of the property are divided up between my wife, her sister, and her two brothers.
It don't matter if she's alive.
Because it's all tenancy as a joint ownership. When she dies, the property then goes to her sister and her two brothers. When her sister dies, it goes to her two brothers. Until finally some person in that line of succession has all the property. Then we have ownership in fee simple. Okay. That means the last person alive owns the whole thing. I will put these up on the website as soon as I go back upstairs.
Yeah, so that's what I'm finding.
Yeah, they're not on there yet, because I wanted to present them at the same time that Mr. Carroll could come in, or Mr. Collins could come in, so I decided to do it right now. Yeah.
To understand this more, so I thought that when you're married, that the spouse is authorized over everything that belongs. If there's no prenup involved, just in this situation, the spouse is over everything that belongs to he or she. But this is saying that it's not.
Not necessarily, no. In a marriage, spouses own all of their property as joint tenants. And we call it joint tenancy with right of survivorship. Because when one spouse dies, it goes to the other, even if it's not in the will. Okay? There are certain states where tenancy is split 50-50. Okay, so there's a what if that goes according to the spousal rights that individuals have when they marry. Say we have a house. There is something we call dower that also attaches to spousal rights. So, if I am divorced from my wife and I sell, or am authorized to sell the whole house, I actually am not selling the whole house. I'm only selling 70% of the house, because common law dowry rights say that she gets 30% no matter what, even of the sale. Same thing goes for a husband. If the wife gets the house and sells it, the husband still owns 30% of the house, also called dower. Very old concept. Okay? Property can be very complicated. This is how tenancy in common works. This wasn't part of the original presentation, but I put this in to kind of illustrate how this works. We have Joe, okay? And we have Joe's heirs. Joe says, I'm going to get my property from Grandpa. So Grandpa actually owns the property. Grandpa passes away. Grandpa leaves the property to the church, to Sam, and Joe. When Joe dies, then Joe's property goes to Joe's heir, and Sam's property goes to Sam's heir. The church gets to keep its property. It doesn't go anywhere, because it's a charity that does not go away. Okay? Does that make sense? I've got more diagrams. I hope they all help. Joint tenancy, we have Grandpa. Grandpa, when he passes away, he's going to leave the property jointly to Milton, Sadie, and Pete. When Milton dies, the property then, his share, then goes to Sadie and Pete. When Sadie dies, it goes to Pete. And Pete, being the last survivor, owns the whole thing in fee simple. Everything in property is designed eventually to come down to one person. That's what I heard during the other video. It's probably a very nice water. Joint tenancy, tenants in common, all designed to come down eventually to one person. Modern statutes presume that any tenancy is a tenancy in common unless the document that signs the property over to the heirs says otherwise. Okay? Tenancy by the entireties is the kind of tenancy we were talking about with spouses. Tenancy by the entireties is between the husband and wife that says that neither spouse can transfer their interest separately during their lives. They have to do it together because it's an undivided 1/2 share in that property. Some states will allow spouses to hold property in community. This is community property. That's where if something happens in the marriage, half of the house goes to one, half of the house goes to the other. And I say half of the house because I mean the value that is half of the house. Okay? So each spouse technically owns an undivided 1/2 interest in the property until they separate and the court approves the distribution of the assets. Then the house is sold and money is split. And this is also a misnomer. The money is not split evenly. The sale price is not split. The bank that has the mortgage gets paid first. The spouses get half each of whatever is left over. Yeah. Mm-hmm. Lenders always get paid first, no matter whether it's business or marriage or personal bankruptcy or business bankruptcy or dissolution of a partnership or whatever it is. Lenders always get paid first. Lenders and creditors, okay?
That's interesting.
That's the way it is. So how do we acquire ownership of personal property? We can get it by possession, production, and gift. Possession, okay? Capturing a wild animal is acquiring ownership by possession. That's like somebody who finds a kitten along the side of the road, and it's an abandoned kitten. They take that kitten. They obtain title to that kitten by possessing that kitten. And if that kitten really likes them, there's no way that kitten is leaving. Had that happen. Those who find abandoned or lost property fall in that category, as well as those who find gold from, say, sunken ships in Florida. That's called treasure trove. It's called treasure trove. So, let's talk about abandoned or lost property. There was a ring over in France that was found by someone who was walking the old battlefields with a metal detector. They found this ring. It was a gold ring. It was a class ring from 1914. He found it. Now, technically, he could have kept that ring. It was gold. It was very attractive, and it had jewels in it. It was a class ring from an American high school. But he said, I'm only going to be the caretaker of this piece of jewelry. I'm going to find out who it belongs to. Took him 6 years. He tracked down the high school. The high school no longer existed, but the Board of Education had all the records. They went through the high school and they found all the people that had the same initials, and then they went through and found from the selective service system, they found somebody from that high school with those initials who lived in that town and went to his family and he gave them the ring. That's a lot of work, but there's a lot of personal satisfaction that went along with that. That's a aw shucks kind of story. So,
Was it worth something?
was it worth something? For him, it was worth the personal satisfaction.
I'm saying that's money.
I don't know if it was worth anything. I didn't read that in the story. They didn't mention it. But land, if you have abandoned or lost property that you find, it belongs to whoever finds it, which is what we call treasure trove. Now, sunken ships in Florida are a special thing, kind of item. When a group of explorers find a sunken ship that has gold and silver and cannons and jewelry and all sorts of stuff like that, Florida gets 90% of it. Because there's a state law that says anything that's found in Florida state waters belongs 90% to Florida. So the explorer gets 10%. Many explorers have sued the state of Florida to try and keep their share of what they recovered and have failed. And, well, here's a good place to ask you. We're going to deal with international law later. Do you know how far out Florida waters go?
To Cuba. That's a Cuba. I mean, because Miami is very close to Cuba, so I would think that people go farther to Cuba.
No.
No? Further than that?
No.
Oh.
The U.S. territorial borders go out 12 miles beyond the United States. States have jurisdiction called admiralty jurisdiction, 1 mile offshore. Most of these ships were lost in storms on reefs that used to be farther out, but the land has built up over the centuries and the years, and the ships now are closer to the shores of Florida. That's how Florida manages to lay its claim. It used to be 5 miles offshore. Now it's only 4 miles. It's less than 4 miles, less than 3 miles, less than 1 mile. Florida gets 90%. Okay? That's the way it is. Production. We just talked about this with Mr. Collins. Writers, inventors, and manufacturers producing personal property create title in themselves and have possession by production. I wrote a 2-series set of novels for my children when I was homeschooling them years ago. Those ideas, that writing, those novels, and the voice-overs that I did. I read it all, and did all the character voices. They all belong to me. And then when my daughter was married, I gave her a copy of the disc with my voice reading that so that my grandchildren will be able to hear my voice no matter what happens to me. I think it's a pretty good book, too. Gifts. Gifts are voluntary. They are voluntary transfers of property to another, made without conditions and without consideration. Yeah, please don't slam the door in there. Delivery. Delivery is when a gift is given away, or the manner to access the gift, such as a key to a safe deposit box, or the combination to a safe, is given to an individual. With gifts, there has to be donative intent. Donative, like donation. Donative intent. It has to be freely given without any duress or fraud. So it has to be given out of the goodness of your heart to somebody else. And then the person to whom it's given must freely accept it. There are 2 types of gifts. Gifts inter vivos and gifts causa mortis. Gifts inter vivos are gifts that are given to someone while they are alive. So, I am alive. I give my pen to Shri. That is a gift inter vivos. I am alive and I give it freely with all the proper donative intent, not really, to Shri. We don't expect those gifts to be returned. Okay? So that's gift inter vivos. A gift causa mortis gets a little bit more complicated. A gift causa mortis is given in anticipation that I am going to die.
Like, say it like that.
Huh? Why do I say it like that? Because I'm a little older than you guys, and eventually I am going to die. So, huh? Or maybe I'll just regenerate like Doctor Who. So, I think I'm going to die tomorrow. So I give Shri my pen. All right? I give that because I believe I'm facing death. It's not completed unless I actually fall over and die. So what happens is, if I don't die tomorrow, you bring that pen back to my office. Yes. I'm here every day, aren't I? Except for days I'm not. No truer words were ever spoken. Other kinds of gifts. Will or inheritance. If somebody writes a will is what we call the last will and testament. It distributes a person's personal property and their real estate and anything else they have. Chattels. If we distribute all their little black and white chattels with horns, we do it through our will. She's going to kill me. She really is. Will or inheritance, then, is a voluntary transfer of property by the donor in their last will and testament. Everybody, if you own any property whatsoever, anybody that owns property, especially real estate, when you get older, write a will. Because if you don't, the state will distribute the property for you according to what they think should be done. And it might not be going to somebody that you would like to have it. Okay? Accession is when someone adds value to a piece of property by their labor or materials. So I go out and I cut down a tree. And I cut down that tree for Robert. And Robert's a fabulous artist. And Robert says, that was a beautiful tree. It's sitting on your property. I'm going to do something with that tree. And he comes over and he carves this tree into a wondrous set of figures, like little houses and people walking on it. The things like you see at Cheekwood, you know. What he has done, and then he leaves it there. That is a gift by accession. He has left that beautiful tree there, but he has increased its value by his artistic expression. Confusion. Now, how can you give a gift of confusion? I don't know. I think that's how Shree got my pen. Confusion is when ownership occurs by an agreement, honest mistake, or by a third party. The owners share the property as tenants in common. So, if there is an agreement, there is an honest mistake, or there is a third party, the owners would share the property with tenants in common. And you can go back to the slides and you can see how that works. If it's done by an act of good faith, by one person, the other people will acquire the title to the whole thing without the others. Other property acquisitions. Mislaid property. If a property has been mislaid, the original owner, not the finder, has ownership to it. We say they retain the title. So, if Jasenia walks off without her computer, and I pick it up and take it into my office, we say it's mislaid. She retains the ownership to it. Nobody else gets it. So, I become the caretaker. Don't you love that? Doesn't that make a great name for a Halloween costume? The caretaker. The caretaker. Ooh, I like that. And has use of the property, so I can use the computer. But also, I have a duty to see that no harm comes to it. In other words, I have to keep it in good shape. If the original owner of the computer does not claim it, which I know is about Ice Cube's chance in, you know where, the owner of the premises on which it was discovered can claim it and call it treasure trove. So Fisk could claim the computer. Okay? Lost property. If property is lost, the owner has a first claim to the property, always. The finder has the second claim. The finder is the caretaker of the lost property until that property is returned to the owner or the original possessor. Failing to return it is what we call conversion, which is a tort, which we have not talked about torts in here yet. But torts are civil wrongs. Conversion is tantamount to theft in criminal law. So if someone does not return lost property, it's like stealing from that original owner. Some states require that the finder attempt to find the owner. It's something we call an estray statute. So when somebody loses, and this has happened quite a couple of times recently, somebody goes swimming in the ocean, and the salt water washes like a ring off of somebody's hand, like the engagement or wedding ring or something, and somebody else all of a sudden will get washed up on the beach. Under an estray statute, the person who found it has a duty to try and reunite that ring with its owner. If they don't, it's conversion, and they can eventually be sued for it. Could be considered to be grand theft, depending on state law.
But how could you ever
Prove that somebody stole your
how could you prove that they stole it, or what is the chances that they even
They lost it. They just lost it. Because like you said, the chances are very slim that they're going to find it. But in cases where it is found, this applies.
How do they prove that it's theirs?
Most rings are both sized and have some sort of maker's mark on the inside, and sometimes the initials of the couple. And that's pretty safe. See, my law school ring. If I lose my law school ring, I can get it off.
It's not gonna be.
Yeah, it's kind of off. Yes, I can take it off. Look inside the ring and tell me what you see.
Lord knows. It's got like some letters. It says Johnston's was intended to.
And
It has your name in it.
it has my signature.
Yeah, your signature.
They engraved my signature into it. That is how I can prove that that is my ring. It has my signature.
How do I get it over here?
That's laser. It's laser etched.
Oh, wow.
Yeah, they had lasers back when I was in law school. They actually did. Yeah. Yeah, Shri.
So what if, like now, like if I'm like super rich and I have kids and stuff, and I die unexpectedly, where do all my belongings go?
Well, the pen comes back to me.
Oh, no, I'm not saying that. Yeah. What about the other people? Like my money and like my house, if I own my own house and car and stuff, what did they do that? Because I wasn't able to make a will because I was.
You don't have a will. There is a statutory will that the state has legislated into state law, which follows the provisions of a presumptive will and distributes it to your next of kin. Now, you might not want your stuff to go to your next of kin. You might not want your next of kin to know what stuff you have. It's generally best to have a will.
If you have a husband, you can exclude your next of kin.
husband is the one who is the next of kin, yes, that's correct.
So what if you don't have a husband, so what, your sister or brother, or your kids?
Well, there's a tier of there's a hierarchy of heirs set up. So if you don't have a husband, but you have children, it goes to the children. If you don't have a husband or children, it goes back to your parents. If your parents are dead, it goes back to your grandparents. If your grandparents are not alive, it goes out to your aunts and uncles. If they're all deceased, then it goes out to your cousins.
So there's no actual siblings at any point?
But how do they
It can
pick
go to
which,
your siblings.
is it
Just
split?
depends on state law.
Is it split between the kids or is it like?
Yes, it's what we call distribution per sturbies, which is by blood.
Okay, so if it has to go to the cousin, then like all the cousins?
So you have 500 cousins, I would guess. Pretty close. You better make a will, because you want to consolidate your stuff. Yeah, Larry.
I know one thing my parents taught me when I was younger, that if my mom was going through some kind of medical thing, my dad will be the only person who has the say so of what they should do to her.
Yes, that's a medical power of attorney.
So the spouse is automatic.
The spouse is the one who signs off on her final wishes. That's true. Yeah. Goes
So like, to what extent would, like, back to the ring,
Malcolm.
to what extent would they have to, like, look for the person?
Malcolm. See, I had to stop and think. Are you Malcolm?
No, I'm not.
You're not.
I am Malcolm, I'm not the.
Well, see, why did you say no?
Because you were about to call me somebody else.
I was about to, but I'm trying to get see. What we're going to do is we're going to give you each a different style of beard.
A beard? I've had my beard since like 9th grade, so.
I think you ought to cut it like mine. This is really cool.
My cheeks are fat. I gotta keep it up. Maybe let's.
Hey, I'm not going to get close enough to find out. Okay. So, what was your question?
Like, to what extent do they have to, like, look for the person who's the ring before they can, like, keep?
Reasonable. Everything is under a reasonable standard. It's like that person from France who found that high school ring went to unbelievable lengths to find that individual. But the records were available.
So they kind of just had to?
They didn't have to. They didn't have to go that far. It was almost 100 years.
It's like a Facebook ad good enough, like you post on
Yeah.
Facebook.
That's good
Facebook
enough?
describing it and saying, where are you from, what year was it, all that kind of thing. You can also list it
How
with,
many times do you gotta post it?
That's what I'm doing. To what
Only
extent
once.
do you have to go to?
it's
Oh,
reasonable.
only
It's a
one?
reasonable standard. If you've made your best efforts, and the courts can see you've made your best efforts, you don't have to worry about anything else.
So, is there like a time limit for these rules in place? Like, I keep thinking of the treasure troves or whatever those things are called. Like, what if a family from way back when that like actually owned the ship or whatever that went down and all that stuff is found? Would that apply still? It's been like over 100-something years.
Well, I would have to look that up, but I'm going to make an educated guess and say that if Florida doesn't have a claim for it, the law which the state of Louisiana has would apply, in that a French ship sank off the coast of Louisiana. It was ruled by the courts that Louisiana did not own it, and that it was owned by the French government. So now the French government has taken possession of the treasure.
What if it's like an individual like family thing? Like if the family were to claim it and be like, oh, this is our stuff, even though it's like 200, however many years old, this is our stuff. Would
Okay,
they
now
be able
let's-
to fight Florida for that?
They're gonna have to fight somebody for that, yes.
Okay.
I'll go to court.
Even though it's been like 200-something years.
That's right.
Okay.
So here's the thing that I think about when I'm doing this. If it were to be in France and Louisiana was fighting with France over this treasure, all family rights to property were terminated during the French Revolution under laws in France. Those laws are still on the books. So it's entirely possible that the French government would be able to take possession of it, even if they did locate the family, and even if the family could identify the heirloom. So, yeah.
So let's say someone is gonna get an inheritance
Yes,
in the future.
an inheritance in the future.
Okay, and then they get married before they get the inheritance. And in the event that, how do they protect themselves from the spouse getting the money in the event that they were to get a divorce or something? Without getting a premium?
Wills are only effective upon death. So if the spouse is still alive and you receive inheritance as the descendant of the person, that becomes your personal property. One of the pieces of divorce law, which is always worked out in the settlement, is who gets what property. The first thing that is discussed in the settlement agreement is property that was the independent personal property of the individual that they brought into the marriage. Well, that could be considered to be property that was brought into the marriage because it was your inheritance and no one else's. So that could be your personal independent property.
And so,
They would have no right to that
okay, so.
unless it's a community property estate, and then different rules apply.
If it's just of monetary value, then it's yours, and if you're divorced, then
And everything has to be worked out between the two spouses.
I thought you just said.
The property acquired after the marriage is property which is discussed in the separation agreement.
Okay, so what I'm asking is, what's the best way to ensure that the spouse doesn't do that in the event that you get divorced without having to get a payment?
Tell your parents not to die until after the divorce.
That's tough.
That's something.
That's so possible. I don't think they're choosing to die.
So even though it's your inheritance, just because you got married automatically, like,
What about all this
specifically-
No, it does not. It does not go automatically to your spouse. It is considered to be your separate property,
Okay,
and it's set out in the
Even though
terms
it's
of
just
the
money.
separation agreement.
like even if it was just money, no problem.
Even if it's just money, it's
So
your
it's-
separate property.
It's yours.
Wait, so if you, I'm confused on what you're saying, so.
It's yours, but
It's
it
still
will be up for
yours.
discussion when you go for divorce.
Yes, it would be up for discussion. Your property is your property. You have inherited it while it was in your marriage, but it's yours. Well, there might have to be something offset by marital property on the other side if your spouse does not have that same amount of assets.
Girl, just get a separate account that you don't know about. Keep it there.
You gonna bring the lies into your relationship? That's
Oh,
crazy.
wow.
Okay? I know, it's very complicated.
Like,
And
can't you get, like,
She don't want to.
prenups, I don't know if we even want to go there
Well,
because
I think we should go there.
they're very complicated because there has to be complete disclosure of all assets by both parties,
What do you mean, like, they have to, we have to know everything?
everything. If one thing is hidden from the opposing spouse, then the prenuptial agreement can be vacated by the courts,
That's crazy.
and
that's too much.
There was a one
it becomes, in California,
Mhm.
where these are especially popular, it can become community property. and then you've lost 50% of everything. Would you like me to name the others, some of the other states where they have community property so you don't go live there?
Yes.
Atlanta, no?
Florida, California, Nevada,
All of this makes sense.
yeah, those and New York. Those are the four that I know about. So after you get married, move to Tennessee. Stay here. Yeah, there's no community property here. Yes.
Can you get a prenup in the middle of the marriage?
In the middle of the marriage? No.
That is not
Prenups become part of the premarital negotiations. You know, like right after the engagement, you say, let's sit down and talk about my assets and your assets.
So there's no protection once you're like already married?
Once you're already married, all bets are
Oh,
off.
that's.
All bets are off.
I feel like marriage should be so like.
And it might even be different, it should be different in Louisiana.
I wouldn't be
They're not
surprised.
Because they function under French civil law for a portion of their
No,
code.
it's Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, Wisconsin.
There you go. Read them out again real loud.
Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, Wisconsin.
Those are all community property states. That means it's 50% right down the middle, unless you have a prenup. So if you're living in any of those states, go see a really good divorce attorney and have him work out a prenup for you before you even get married.
That's what you have to be that deep.
So shameful.
And then, and I'll be ready for this, and then your spouse's parents are going to say that that's so unfair. How can you even think about doing this to our son or daughter? That's just unfair to say they don't share in the bounty of your marital wealth.
It's also unfair if they cheat or something, but that's just
That's worked out in court.
In
The dog is sometimes included in property sales.
They can keep it. If it is that they don't keep it.
Yeah. Just one more. This is it.
Okay, what if you have like the money in an account with someone else? Like what if you have a joint account with someone else?
It better be, if you do that, it still has to be declared as a prenup.
Like if you have business with somebody.
Yeah, or if you just,
Like your brother having
like,
one.
yeah, like what if you have a joint account with like your sibling or something?
Oh, boy.
And then
What the
you-
court is going to do is split that account right down the
But
middle,
what if
give
you-
half of it, wait a minute, give half of it to your brother, attribute half of it to you, and then that goes towards the marital assets.
Hold on.
But it doesn't all belong to me.
No, but it's not tenancy in common.
They doing the most.
It's joint tenancy with right of survivorship. Bank accounts are about 90% right of survivorship.
Wait, what, so half couldn't even go to the sister?
What he's saying is the money is split between you and your sister, and the money that you get is gonna be put up for discussion in your divorce.
That's right.
It's like your brother get 50.
Just-
you probably
just-
get 5.
Just your portion
But
is discussed.
I think her point is that maybe it's $100,000 in an account, and her sister really owns $70,000, and $30,000 is hers, but they still gonna take that 50. and split
Not
it.
necessarily
Oh,
now.
okay.
Under your description, where 70% of it belonged to one of the siblings and 30% belonged to the other, the court is going to ask for proof that that sibling deposited that amount and had that amount of interest accrue on it, the 70% to keep it out of
Okay.
the problem. Otherwise, it would be split 50-50. Now,
Can
let's
you just
go on.
give like some shit to somebody else?
I somehow have a feeling this has happened in the family. I don't know why.
Did you get a prenup?
Hmm?
Did you get a prenup? How did you do it?
You can get a prenup that involves that.
He said, you.
I did not, no. You know why? You know why I didn't?
You want a prenup. They're gonna be like, so you thinking about divorcing?
Like,
I'm not.
It's just protection.
Would that same situation apply to your child?
I can't hear you. Okay, settle down, let's finish this out.
What if it's that same situation she was talking about, but with your child instead of your sibling? Like, if I had a joint account with my mom, my parents get separated with that money. Since I'm the child of like both of them, same rules would apply. It wouldn't get any
Well, if
different.
I can have my money.
Your mom should put that money into what we call a minor's trust account at the bank.
What if the account's in my name and she's the joint?
It's your name.
Oh, yeah.
She is the trustee. She has no power to withdraw the money because
That's actually.
it actually becomes yours. Okay. Okay. So that's lost property. Bailments. Bailments include delivery of items in transit or pawning of items. So if I pawn my watch and I go in and they give me $50 for my watch and they keep that watch and they give me a ticket for it and say I can come back in and pick it up if I pay the loan back, that's called a bailment. That's what that transaction is called, a bailment. I take the watch in, I get the $50. I've used the $50, I got it back, I go back in with the ticket, I pay that $50 back off, I get my watch back. That was a bailment. I'm bailing out my watch. Same principle. Same principle. Okay? Same principle. Delivery of items. If we have cars on, and you see CarMax delivers cars all over the country. What those drivers do, they're independent drivers, they're independent contractors. They put those cars onto the truck and they drive them various places. Those are called bailments because they get paid for the number of miles and the number of cars they're hauling based on the paperwork. So they take the paperwork, which is called a bailment, so the driver's a bailee, and they take that paperwork and they deliver a car and they turn the paperwork into the dealer. That car is at the dealer, they get paid, that part of it's done, and they keep doing that until they've delivered all their vehicles and they're reimbursed for all of their expenses and their pay. Okay? A bailment is created by the agreement or contract in which the title is transferred without intent to do so. So the person who's driving the truck temporarily has ownership of all the vehicles that are on that truck. The elements of a bailment, they involve personal items more often than intangible property. So cars are chattels. They are personal property. They are moved from place to place. I just thought of another really bad dad joke, but I won't do it. Because somebody's going to heave her water jug at me. Elements of a bailment. Bailments involve personal items more often than intangible property. Delivery requires a surrender of exclusive possession and control, and knowing acceptance and control. So, the people at the various CarMax dealerships that are transferring the cars from one dealership to another surrender control and possession to the driver. The driver knowingly accepts the possession and control of those cars on that trailer until they can be delivered. The agreement requires the return of the bailed item to the original bailer or a third person unless the goods can be substituted for money. Any good that can be substituted for money in the case that the item disappears is called a fungible good. Fungible. I do not know the origin of the word. I would have to look it up. But it is called fungible in the law. That means it is substitutable. The bailee has a right to temporary control and possession A right to use the property for the purpose of the bailment. That means that the guy takes the cars and puts them on the trailer and takes them off the trailer. He doesn't have the right to take them off the trailer and drive them around. There's a right to be compensated or reimbursed for expenses, and there's a right to limited liability by the type of risk, money amount, or both, if public policy does not prohibit it. Okay, so there's a bailee is kind of insured for what's on that truck. Common types of bailments are common carriers, like the truck that carried it, warehouse companies who store things in their warehouses, and innkeepers, where property is brought into the room and it has to be safeguarded. Most hotels have safes to guard valuables. So, a bailment, and a bailment that you can be sure that will work, is one where you take your valuable items and put them into the safe in the office, in the hotel. These little safes in the rooms do not, if you read the sticker that's on them, there is no liability of the hotel for any of the items that you put into those safes. And those safes can be broken. Real property. Real property is land, and land includes soil, subsurface, air rights, and any fixtures. Airspace and subsurface rights, there are limitations. They are indicated in the deed. So your property rights for a piece of real estate go all the way down to the center of the earth and all the way up to the edge of the atmosphere. Normal airline overflights do not reflect a violation. So airplanes are allowed to fly over because that is a transportation necessity under federal law. Rights to minerals, oil, or water can be sold separately. Any of these rights, air rights, surface rights, or underground rights, mineral, we call mineral rights, can be sold separately. My family used to own land which had coal underneath it. We sold the subsurface rights, the mineral rights, to a coal company who mined it. We received a percentage of the sale of that coal per ton. Subsurface owners are liable if surface owners are damaged by excavation beneath their land. So it's always a good idea that the subsurface owner for the mineral rights and the surface owners that own the real estate are on the same page.
It is infected by a virus and/or spyware. This virus may be sending your credit card details, Facebook login, and personal emails to hackers remotely. Please call us immediately at the toll-free number listed. So that
It's a scam, and you know it is.
Yeah, I'm trying to take
over the phone.
Ownership.
Close this page before calling us. We will be forced to disable your computer. Error number 26883. Critical alert from Microsoft. Your computer has alerted us that it is infected by a virus. This virus may be sending your credit card details, Facebook login, and personal.
I had a real good solution. It's called. Okay, ownership. Ownership. Again, we have real estate ownership in fee simple. We have life estates. Now, a life estate is where someone grants somebody else the right to use or live in the property for life. And when they die, it goes back and is disposed of under terms of, say, the will or the deed. So I have, my wife Cindy and I have a home. We have a son. Our son is autistic. He will have a right under my will and under her will to live in the home that we have now until he is deceased. So he will always have somewhere to live. So that is what a life estate is. It will be in our wills, and he will have the right to live in that property. Leasehold estates. You know what a leasehold estate is. It's where you lease the property. You lease your apartment. You lease your dorm room. Tenancy for years. The person holds the property for a specific period stated in the contract. gonna rent this house for 20 years. That's what it says in the contract. And what happens when those 20 years are up? I gotta move. Periodic tenancy. It's no specific period stated in the contract, but it's determined by the payment period of the rent. Sometimes we have month to month. Month to month is the easiest one to illustrate. I pay my monthly rent this month, I can stay in the property this month. If I don't pay it next month, I have to go. Tenancy at will is terminable at will of either the lessor or the lessee. So the landlord can come in and say, I, as your lessor, terminate your right. But it has to be a tenancy at will. It has to be in the contract. Tenancy at sufferance. Tenancy at sufferance. This is a good one. This is possession of land without rights. It's created when a tenant stays in possession of a piece of property without the permission of the owner. So, we can't find the owner. We've been sending our money to a post office box for the last 15 years. We don't know who the lessor is. But we're just going to stay in there until they show themselves. That is tenancy at sufferance. We're just going to hold on to that until we find out. Then you go see a lawyer because you might be able to actually own the property. Especially if you've been paying the taxes on it. Non-possessory interests is an easement. An easement allows a person to use the land without taking anything off of it. So if we have an easement for an electric company, they're going to put electric lines down the side of the house. Okay, so we grant them an easement. They pay us for the easement. They pay us for the easement and they can put the lines there. That's it. They can use it, but they don't change it. Profit. A profit allows the use of another's land from which valuable resources may be taken. I rent land with the intention of harvesting timber. That is called a profit. Or I rent the land with the intention of using it to take oil out of the ground or natural gas. But then I'd also have to negotiate for subsurface rights. Transfer of ownership can be by deed. You pretty much all know what a deed is, right? Inheritance or will. Talked about that. Adverse possession. You can use those three: deed, transfer, or adverse possession to transfer ownership. Limitation on the right of the property owners. Well, there's a thing called eminent domain, and eminent domain is the power of the government to obtain land for public purposes. That's Fifth Amendment. They have to sue for condemnation if they cannot negotiate a good price. Zoning. Under the police powers of the state, uses of land are regulated without the owner having to be compensated unless the restriction is too great and would violate the 14th Amendment to the Constitution. I am having a couple of attorneys who specialize in land use and zoning in the afternoon class, the 2 to 4 afternoon class. I don't know when yet. It'll be sometime this month on Tuesday or Thursday from 2 till 4. If you want to come and hear about zoning, these are the folks you want to hear, because one of them has been doing zoning forever, and he knows like the back of his hand. And there's some people that are very interested in it because zoning affects everything. Zoning affects flipping houses. It affects, can you build a house at all? What kind of property can you put a use for? Commercial, industrial. What does all that mean? How do you downzone something in order to make sure that it's safe from being split up into 2 or 3 different houses on the same lot? You know, just all that kind of stuff that's going on around Nashville right now is what they do, and they watch, they take care of. So you might consider, I'll tell you when they're going to be coming in, and might want to come and listen to them, because they'll be very interesting. Well, I know David is just a real dad joke person, too. Oh, I just ruined it, didn't I? David knows a lot of dad jokes. Creating the relationship. Temporary possession distinguishes a tenant from a purchaser. Yeah, it's temporary. Anytime you rent something, or it's a leasehold, it's temporary. We intend it to be temporary. Form of lease may be oral or written. Illegality, an owner may not discriminate, for example, on the basis of race, religion, natural origin, or gender. And now let's add age to that. Like I said, these slides have not changed in about 5 years. They haven't changed because property law just does not change. It is one of those things that's almost immutable. Parties' rights and duties, we have possession, use of premises, damage to the premises, and rent. I'm not going to go through these. They're very long and it's getting very late. So I'm thinking I'm going to keep going. No, you're all starting to fall asleep. What I'm going to do is I'm going to put these up on Canvas, and you can just read them, the last 3 slides yourself. Okay?